Something I wanted to ask you about is the fact that even though we're now in 2021, it seems that there is still an issue about whether there's an assumption that women bear the responsibility of childcare more heavily than men. You know, there's a whole series of indirect sex discrimination claims where the courts have said, yes, that's an assumption that can be made. And then later it's been suggested, well, you might not assume that about all sorts of professions and all sorts of jobs. But why are we still talking about this now?
That's a bit bizarre, doesn't it? The assumption that women are going to bear the majority of the burden of childcare was one where we had to certainly live with in the 80s and the 90s and the noughties. Here we are in 2021, and the EAT has said that in two cases where we've looked at this is still something that is the reality for women today and still something that courts can take judicial notice of. We've looked at Hughes and Progressive Support and Dobson and North Cumbria NHS, both of those cases which will be in the sex discrimination part of the book, and both which deal with the requirement to work particular hours, which were difficult for the claimant, who was a woman. I think in Hughes, it was a 24/7 care for adults with disabilities, and the employer initially agreed to a pattern of work which the claimant could manage, and then temporarily they were withdrawn and she was required to work hours which she couldn't manage. And it was a real problem for her. And in Dobson, that was the NHS, and she was a community nurse. And the community nurses, it was a change that they were required to work flexible hours, including some weekends. And the claimant, whose responsibilities were for childcare, couldn't manage those flexible hours. And in both cases, the tribunal got it wrong, and the EAT had to set them straight. In the Hughes case, Mrs. Justice Eadie said that the PCP, the policy, criterion or practice, had been applied to her, that the sanction about the standard hours had been improperly applied. With hindsight, she'd suffered a detriment because she wasn't able to work her guaranteed hours. And that was because of her childcare, and it was sex discrimination because she was a woman, the relationship between women and childcare. And in Dobson, Mr. Justice Chowdhury said that the tribunal got it wrong by looking at it too narrowly. They looked at the pool for comparison was just the team that the claimant worked in, rather than looking at all the people across the NHS trust who were required to do the flexible hours, because the PCP had been applied to all of them. And it was in that case that Mr. Justice Chowdhury said it's still important for tribunals to take judicial notice of the fact that childcare obligations are still, in general, likely to bear more heavily on women than on men, the so-called childcare disparity that he mentioned.
Yeah, so in many ways then, those two cases, although the claimants have kind of got over that hurdle, is it going to come down to justification, would you say?
I think that's right. The cases don't mean that the claimants with childcare responsibilities will always get it their own way, and that the employers must always make adjustments for them. It's the question of justification. The real battleground is about whether there's a legitimate need of the employer and a proportionate response from the employer. Because in those two cases in particular, you've got employers who deal in care, 24/7 care for adults with disabilities, NHS care. And so they may well be able to show a legitimate need to have their employees work flexible hours, work hours which are non-standard, in order to actually provide the service that the business is there to provide. And so both cases, the issue was remitted to the tribunal for the big question in Hughes: does this care company need to have the flexible hours, and how do you balance its need for flexibility with the claimant's need for flexibility so that she can manage her childcare and carry on working? And the NHS, again, I suppose another issue, even more complicated, would be just to put into the mix if you're caring for a disabled child. There was a Northern Ireland appeal case, wasn't there, Macquarie, which looked at the added impact of care for a disabled child and whether you could claim associative discrimination if your employer treated you differently because of your care for a disabled child. All very tricky and all very interesting.
It is, and it's possible, I suppose, that if you're caring for a disabled child, that is a route by which a male parent can actually bring a claim, whereas of course they can't claim sex discrimination on the state of the law as it is at present. So
I think that's right.
Quite an interesting thing too.
Another strike for equality.